So welcome everybody. I am Laura Grossman with the IAA. Welcome to this member call on record keeping best practices. This call is being recorded today, November 29th, 2022. As you know, and the reason you're here is there have been some recent SEC enforcement cases relating to the use of personal devices for business purposes, some with very large fines. I know there are a lot of questions about what this means for advisors and what to do about it. We are very fortunate to have two guest speakers who are both partners at IAA Associate Member Willkie, Farr, and Gallagher. We have Adam Aderton, who was most recently co-head of the SEC Enforcement Division's Asset Management Unit. He joined Willkie a couple months ago. And we have Anne Choe, also a partner at Willkie, who's been there for 13 years and counsels mutual funds, ETFs, and private funds on a wide range of regulatory, examination, and enforcement matters. So Adam and Anne are here today to help give us some context for these enforcement cases, share some possible approaches to consider taking, and field your questions. So I will turn it over to them.
Thanks, Laura. Thank you all for dialing in. I will tell you that when I left the SEC this summer, I did not expect that the number one issue I would be talking about was record keeping, but here we are. And I was actually at a conference this morning where Director Graywall again highlighted the importance of record keeping obligations and his view that he sees them as foundational to the SEC's mission, and so therefore they will continue to be devoting resources in this area. I also have heard them analogize text messaging and record keeping related thereto to email from the late 1990s and early 2000s. I have been doing this long enough to remember that and to remember the challenges that we all faced in bringing email into routine surveillance. And I think this is something that eventually we will get through, but I think there's going to be a lot of change in practices along the way. So with that, thanks so much for joining us for this hour today. I'm going to give a roadmap for how we will be progressing through our hour. Please do feel free to interject with questions at any time. Anne and I have a goal of making this as practical and useful for you all as you think about how to apply to your businesses as possible. In terms of the roadmap, after I finish this introduction, Anne is going to walk us through the statutes and rules that are relevant for you all from the investment advisor perspective. I'm going to talk about recent enforcement and exam activity, and I'll start, of course, by talking about the broker-dealer sweep that was announced back in September. Anne is going to offer I'll hand it back to Anne to walk through some of the practical guidance that we have been thinking about and suggesting that people consider in how to respond to the SEC's record-keeping requirements with respect to text messaging. And then Laura was gracious enough to share a number of the frequently asked questions that the IAA has already received. And so Anne and I will work through those questions in addition to any questions that you all may have as we go through today's hour. So with that, I'm going to hand it over to Anne, who is going to walk us through the applicable rules and statutes and sort of help lay the groundwork for the issues that we're going to talk about today.
Great, thank you, Adam. So I'm going to briefly cover the regulatory framework for investment advisors as it relates to record keeping. And we're going to start with Section 204, which is under the Advisors Act and requires non-exempt advisors, so registered advisors, to file periodic reports with the SEC and make available for periodic examinations. Rule 204-2 is the record-keeping rule, which mandates record retention and has been adopted in part to facilitate the SEC examination process. So in this world, we are concerned about a particular provision under Rule 204-2, which is 204-2A7, which fundamentally is a record-keeping provision. And as you know, the record-keeping rule is very broad. And under 204-2A7 Romanet 1, it broadly requires the retention of originals of all written communications received and copies of all written communications sent by the advisor relating to any recommendation made or proposed to be made or any advice given or proposed to be given. So the phrase relating to is notably broad, and we think this is the particular provision under 2042 that the SEC will point to in connection with any off-channel communications that relate to investment advice. 2042 also captures originals of written communications related to any receipt, disbursement, or delivery of funds or securities, as well as the placement or execution of any order or to purchase or sell any security. So just stepping back, the Advisors Act provision does not cover the entirety of an investment advisor's business, but rather only communications related to those specified categories. So there is a debate going on whether or not folks will challenge the SEC and say, look, all communications related to business is not necessarily a 204-2 record. And we think that is something that is worth debating. But the SEC, in connection with their examination program, their investigations, we think they're going to interpret that particular provision very broadly and capture any communications that relate to anything related to the advisory recommendations. And as Adam noted earlier, this is really similar to the requirement for an advisor to maintain email communications. As you know, the SEC has an expectation that all email communications are archived and retained. And similarly, there's no requirement under 2042 that actually explicitly says email communications need to be retained. They're going to point to one of these particular provisions that I just cited to as their statutory justification. And then jumping towards 20647, we also wanted to note that 20647 is the compliance rule, right? And that rule requires advisors to adopt and implement written policies and procedures reasonably designed to prevent violations of the Advisors Act. And so the SEC has an expectation that the advisor has adopted provisions to address compliance with 204-2, and therefore we would expect the SEC to require policies and procedures addressing compliance with the record-keeping requirements. So that's a very high-level framework around the statutory provisions. I'm going to actually turn to the issue of the risk alert that the SEC back then in OC in 2018, now the Division of Examinations. This is actually not a new issue, right? They issued this risk alert back in 2018, and the record-keeping risk alert prioritized both record retention as well as rapid production to the SEC in connection with their examinations. So keep in mind that the SEC under 203(e)(6) can censure an advisor if they willfully violate the federal securities laws, both when engaging in off-channel communications and in failing to supervise others who engage in off-channel communication. So in the absence of records, if you're not able to produce records related to business communications that are a required record under 2042, that can be seen as more than a deficiency in connection with an SEC examination. The SEC, they might view a failure to retain a record as a potentially willful attempt to deny it relevant records that it needs to properly examine advisors. So that's why we're taking these series of actions pretty seriously, because it could refer a matter that might start in examinations over to enforcement. And so the risk alert, just very briefly, wanted to highlight certain practices that the SEC back in 2018 had indicated as being a good practice. So they suggested specifically blocking certain applications or messaging applications that can be readily misused in connection with the business communications. The alert also noted that in the event that an employee actually receives an electronic message in a format that the firm prohibits for business purposes, then there should be in place a record retention policy, similar to what I mentioned about policies and procedures. And then they reiterated that advisors should adopt policies and procedures in place to retain the federally mandated records should they be created in an off-channel format. Finally, the alert notes that there should be in statements and policies and procedures informing employees that a violation of the requirement may result in discipline or actual dismissal. So that goes along with the escalation of disciplinary measures that we're going to touch upon later today. Finally, I wanted to note that the risk alert highlighted and emphasized employee training and attestations with regular reminders about what is prohibited and what is permitted. And we'll touch upon those practical aspects later on in our webinar as well. So with that, I will turn it back to Adam to talk about the broker-dealer sweep.
Thanks, Anne. And I think it is really important to think about what Anne just highlighted, the fact that the SEC has this risk alert from back in 2018, really, I don't know that it was perceived as much at the time, but was a precursor, I think, to what we saw with the broker-dealer sweep that was announced in September. But in terms of getting into the broker-dealer sweep, there was a JP Morgan case back in December of 2021 that looked at record-keeping obligations under the broker-dealer provision, which is even broader, much broader than the investment advisor provisions. Although, as Anne said, we think it likely that the SEC will probably try to read the advisor provision in a similar way that it read the broker-dealer provision. But in that JP Morgan case and the order that came out associated with that case, there is language suggesting that the SEC thought that particular investigations might have been impeded by the inability for the respondent to produce documents. And what I gleaned from looking at that case and then looking at the subsequent sweep is that the SEC likely realized that if they found this problem at one large broker-dealer, there was an opportunity or a possibility that the same problem existed at a number of other large broker-dealers. And I think that's what we saw when the sweep was announced in September of 2022, right before the end of the SEC's fiscal year. So just to talk about the specifics of the sweep, the SEC issued 11 orders that covered 6 broker-dealers, 9 dual registrants, and 1 investment advisor. The respondents in these cases were among the biggest dual registrants, in the financial markets, and every order save one, which I'll come back to, had identical violations of Section 17 of the Exchange Act and Rule 17A-4B4 under the Exchange Act, which are the broker-dealer record-keeping provisions. And then each order also had a violation of the failure to supervise provision of the Exchange Act. Interestingly, in the one action involving an investment advisor, that order included the charges that included charges under the provisions that Anne was just talking about today, Rule 204-2A7, and then Rule 203 or Section 203E6 of the Advisors Act, so the failure to supervise provision and the record-keeping provision. A few takeaways or a few interesting things from the broker-dealer sweep orders. First, the orders were largely template orders and were similarly structured. The factual recitations had slight variations, but were essentially the same. The violations were the same, and the undertakings, which we'll come back to, were also the same. To the extent firms were similarly situated from a size perspective, the financial penalties imposed were the same. And I would take a moment here to note that the financial penalties here were the largest in a record-keeping case by more than an order of magnitude. The penalties for the largest settling firms here were $125 million with the SEC, and there were concurrent settlements with the CFTC. The total monetary relief from this set of cases was a little bit over $2 billion. A few other interesting things to focus on in these orders is that the SEC required admissions to settle these orders. So every one of these orders includes admissions of the conduct and acknowledgement of a violation of the federal securities laws. As I think people on this call know, it's unusual for SEC settlements to include admissions. And when they include them, it's often in a case where the SEC wants to make a particular point about responsibility. I think that's what we can glean from the inclusion of admissions here. Each of these orders had the same time period, which was 2018 through 2021. I think some interesting things about that time period. Well, one interesting thing about that time period is that a lot of that period was the onset and the early stages of the COVID pandemic, when you might have expected to see an uptick in the number of text communications and other what the SEC calls off-channel communications. But I think it's interesting that they extended the period back. I suspect that was an effort to deflect some any criticism that might come from an argument that this was just related to COVID. Each of the orders focuses on the conduct of senior personnel, and I think this is an important takeaway that we can look to right away. The SEC included the failure to supervise charge, and they also included language about senior personnel. And I think the reason that they're doing that is to convey the idea that tone at the top is important, and that they expect that senior leadership and senior management are going to be communicating the need to move communications onto approved channels and not to engage in off-channel communications. I next want to turn to the undertakings in these orders. And one of the things that's particularly interesting to me about the undertakings is that the SEC has now pointed to these undertakings in subsequent statements as what they call a roadmap to compliance for similarly situated firms. This is a relatively new tack that the SEC has been taking, where they will point to the undertakings and say, these are the ways that you can bring your company, your firm that was not a subject of this enforcement action. These are some things you should think about in terms of how you could comply with the federal securities laws. I think that there are things that we can glean from the orders that might be applicable to your business, but I think it is important to tailor any implementation of the undertakings to your particular business. As I said, with the broker-dealer sweep, all of these were some of the largest firms in the financial industry, and the things that make the most sense, or the undertakings that make sense for the SEC and that particular party in a settlement, may not apply to your business depending on the size and the nature of your communications. But just going through the undertakings, so the SEC required all of the settling firms to retain an independent compliance consultant, and that consultant was charged with conducting a comprehensive review of the policies and procedures around electronic communications. The consultant was required to review the training to ensure that ensure that personnel were complying with the requirements. And importantly here, and this is one of the practice points that we'll come back to, the undertakings required quarterly certification from personnel that they are complying with the requirements of the record keeping with the preservation requirements. The undertaking also required an assessment of the firm's surveillance program to determine whether communications are happening off channel, an assessment of technological solutions, including an assessment of whether employees are likely to use the technological solutions, an evaluation of technology or behavioral restrictions. So for example, in the case of a broker-dealer, a policy that personal phones cannot be brought onto a trading floor or something similar. That's a provision that's called out in the undertakings. The undertakings also required a review of the firm's oversight of non-compliance with the policies. And I think this really goes to something that Anne was talking about that calls back to the risk alert about whether firms are disciplining employees for failure to follow the policies. And in particular, one of the things the SEC seems to be concerned about is whether that discipline is disparate for senior managers versus for more junior personnel. And it's something for firms to consider as they're looking at their own disciplinary policies. So there's a lot in these orders, and I've summarized it pretty quickly. I suspect that many of the people on this call have read these orders, but it's worth a reread and a read again to see how any of the facts in the particular order might map onto your business, and in particular, how any of the undertakings might be something that you could pick up and use to strengthen your own compliance program. And I think that's particularly important now, because the next thing we're going to turn to is that after these orders were issued against the broker-dealers back in September of 2022, we now know through public disclosure and through reporting that there is a sweep going on with respect to registered investment advisors, essentially focusing on the same issue. As Anne said, the statutes are different, but the issues are similar, and the requests are similar. It looks like the approach is the same, a sweep investigation to try to get at record-keeping issues under the Advisors Act. And I think we should expect something very similar in terms of the SEC's approach, where if you look at the orders for the broker-dealer cases, they sampled employee devices from a sample of employees. So was only maybe 30 employees who were involved in whose phones were imaged. I say only, that's a lot of employees, but 30 employees' phones imaged in most of the broker-dealer cases. And then those phone images were evaluated for off-channel communications. The expectation is that something similar will happen in the registered investment advisor sweep. And I think, it remains to be seen what happens there. It remains to be seen how successful advocacy on the part of the defense bar is with respect to the differences between the Advisors Act and the Exchange Act. I think that there will probably be people who make those arguments, but the SEC to some extent has proof of concept with the broker-dealer sweep, and it's not a surprise to me to see them roll it out in the registered investment advisor space. So to sum up, this is a clear focus for the SEC in terms of their enforcement program, but we're also seeing it on the exam side. So even if you have a business that hasn't been involved in the current ongoing registered investment advisor sweep, it's reasonable to think that you will be asked about this in an upcoming exam. It's reasonable that if you have an enforcement inquiry, that this kind of conduct might get scoped in. And so given the need to be on top of these issues, I'm going to hand it back over to Anne to talk about some of the practical considerations we've been evaluating and some of the practical advice that we've been giving for folks to hopefully review their programs and get them to a place where they're comfortable presenting those programs to the SEC.
Great. So turning to the practical advice, we wanted to start with adopting and reviewing your policies and procedures to ensure that they're reasonably designed to capture the required communications under 2042. And so we are recommending a re-up and a refresh of those policies and procedures and actually assess the implementation of those policies and procedures through training, testing, and consideration of potential tech solutions. So in general, we've seen two broad approaches. So the first approach would be kind of biting the bullet, accepting that folks are text messaging for business communications, taking in consideration your business needs and your client needs, and finding a tech solution so as to retain and archive text messages and other approved messaging apps. Some firms are adopting a two-device policy where you have a personal phone and then you have a business phone, and all the business communications are captured on the business phone and archived pursuant to some of the tech solutions that we're going to talk about shortly. We've also heard of folks evaluating sort of bifurcating the employee class, figuring out which employees are more high risk, client facing, more senior folks who really have a business need to engage in text messaging for business purposes, and adopting a tech solution for those folks. Other firms are permitting a single BYOD device, but implementing a tech solution on that one single phone on that single device. The second broad approach is where we consider sort of the state of play where most people were today, maybe historically, which is to have a device. It could be single or dual device, but say, look, only business communications are supposed to be done through business email that's archived and retained, and then enhance your policies and procedures and implementation of those policies and procedures to ensure that there are no off-channel communications. And so when we think about the actual enhancements to the policies and procedures, I think a starting point will be evaluating the broad language for what's required to be kept on channel versus off channel. So we have seen firms take a more narrow reading of 2042 and giving more discretion on the part of the employee and making a determination about whether a text is a required record or not. We think that's generally a risky approach because we think the SEC is inherently suspect of employees making their own determination about whether something needs to be moved on channel. Instead, we're generally advising policies to potentially include a narrow carve out of messages that can be made through text messages, including, for example, administrative texts about calls, meetings, etc. So I think the goal really, for at least from the SEC's perspective, is to push as much as possible over to the retained records. Again, think of the email retention issue. So I think Laura had actually communicated through a chat a question as it relates to policies and procedures that I thought might be a good time to insert. So Laura asks, is it acceptable to have policies and procedures that states that the only allowed form of communication related to investment advice is business emails that are captured? However, if you have a business phone and a business team chats are not captured and therefore can only be used for administrative communications without being captured. So we think that's an acceptable approach. That sort of falls under the second broad category of where we've seen firms adopt. Basically, the framework is we're not capturing text, business text messages. We're not adopting a text solution. So the policy has to be that any business communications that potentially could be a 204-2 record need to be maintained on the business email. Okay, so continuing on with some practicalities, I think an important component is going to be on training. So enhanced training on the firm policy and the need to retain communications. The use of recent settlements to demonstrate the importance is going to be a factor. I think it's going to go a long way with your training for employees in this area. We've already seen senior folks reach out to our legal and compliance contacts at our clients and on their own initiative because they're seeing these huge penalties being brought down by the SEC. We would also recommend compliance attestations, and there's been a lot of discussion about the frequency of those attestations. Can they be made only on an annual basis? A lot of folks have annual compliance attestations. We're encouraging or generally kind of pushing and advising quarterly attestations only because that's consistent with what the undertakings that Adam had mentioned earlier. We've also drafted a sample fulsome attestation around this particular topic based off of settlements that we've worked on across from the SEC and CFTC related to off-channel communication issues. So we're seeing folks implement sort of a bespoke one-off quarterly attestation related to this particular issue. Now, another practical area is in the area of testing. We're getting a lot of questions around how to actually test for compliance. How does the SEC actually expect you to surveil compliance with such a policy? And we don't think it's necessarily required or a need to spot check personal phones if you can demonstrate reasonable testing in another method. And the other method that we've seen folks implement really relate to the search review, right? Email surveillance, using updated lexicons. We've prepared sample lexicon searches for email review that are intended to pick up communications to indicate that somebody is routinely or regularly engaging in off-channel communications. It's going to be important, as you know, to follow up on any violations. And compliance consultants also regularly can be engaged to do this type of email testing and surveillance review. Now, maybe I think this might be a good time to turn to Adam, if you want to go through some of the tech solutions that we've discovered.
Sure. So this is one of the things that's called out in the undertakings in the broker-dealer orders. And I think it's important to acknowledge at the top that there is not a perfect technological solution, and there's not an easy button to push on this. Maybe someday, a year or two from now, someone will have figured out the easy button, and we'll all be using a particular product that really solves this problem. But we're not there yet. And so a few of the things that we have seen firms do include to the extent that you're using firm devices, probably the most bulletproof way is to disable iMessage, to default to SMS, and then to enable some kind of software on top to collect those SMS. As we understand it, there are at least 4 companies in the market now that can do this: Smarsh, Global Relay, Telemessage, and a company called Leap Expert. That is one approach, and I think those are the technological solutions that are currently sort of state of the art for SMS. Once you have those, you can ingest them into your email, into your periodic email and other document review that you're already doing. So that's one thing. Another thing that was called out in the SEC's broker-dealer orders is the use of WhatsApp. And so there are solutions that we understand are in the market with respect to WhatsApp. In particular, there's a version of WhatsApp that is an enterprise version that you could require employees who need to use WhatsApp or who feel that they need to use WhatsApp to use the enterprise version, and then you can add on an archiving solution from Smarsh or Global Relay or Telemessage on top of that, so that those do get ingested into your periodic reviews. Obviously, both of these options have costs, and it's going to require some change management to ensure that people are using SMS if you're going to allow text messaging, and that it's using it in a way that it is captured by these softwares that run on top of the phones. If you do go to a full corporate issued device, another suggestion is to ensure that secondary devices just do not have access to firm systems. There's sort of two reasons for that. One is the obvious reason that if somebody can't access the firm systems, then to the extent they're having communications on those systems, they won't migrate over to the personal phone as easily. And the secondary, I guess that's probably the primary reason and the reason to do it. If you're going to go this route, if you're going to go either route, you want to make sure that you have the ability from a technological perspective to manage what happens on the phone. So if it's a BYOD, you want to make sure that you have an overlay such that firm systems are segregated from personal systems. And the last thing I want to talk about is there are some areas where it's just very difficult, and one of the big ones is WeChat. My understanding is that a lot of the business that happens, particularly in Asia, happens on WeChat, and there are not great technological solutions. We did hear just last week that Telemessage may now have an API for WeChat, which would be a way to start to collect and analyze WeChat. But I think what the overall takeaway from this discussion of technological solutions is that these solutions are starting to come to market. And my expectation is that, not unlike email, there will over time develop an industry standard and a couple of providers who can provide really good service here. Maybe not with Apple products that don't play well with everything, but if we can move everyone off of iMessage and onto SMS, it may be possible that we can bring this all within the regulatory perimeter.
Another practical question that we've gotten from time to time relates to disciplinary measures and how we demonstrate to the SEC an escalation or sort of identification of disciplinary. And so we've kind of put our heads together and try to brainstorm some possible disciplinary measures here that we just wanted to share with the group. I think the easy one would be enhanced one-on-one training when you discover a particular violation, and documenting that enhanced one-on-one training. You could have a written warning in the employee file related to the disciplinary measure. And then you could actually require that individual to have a firm issued device and adopt the tech solution for that particular device. That's a potential area. You could remove texting capabilities for a firm issued device, and you can also remove any messaging apps for that particular device. You could also implement random audits for unapproved texting. This is not palatable to the business and not palatable to when we bring this up, but that's an option. You could actually, more as a threat, right? Violation could incur a random audit of taking your personal phone and actually reviewing and testing to determine whether or not there are business communications. There's also compensation considerations, whether or not you'd want to implement a penalty for a violation, effect on bonus, and those types of questions. You encounter sort of employment potential issues, so definitely run that by your employment lawyers in connection with any monetary penalties and the like. Okay, so Adam, you're not seeing the chat, but we are getting really great questions. So maybe I can start with the chat questions, and then we can go on to some of the FAQs that Laura sent in advance. So the first question is, did the SEC image personal phones of employees in connection with the inquiry?
So let me tell you, so the short answer is I don't know the answer, but let me tell you what I understand about how the SEC thinks about personal phones, and how other regulators, based on some comments I've heard in the last couple of days, think about regular phones or think about personal phones. If there are documents that are on personal phones that are responsive, the SEC's expectation, and I think other regulatory authorities' expectation, is that those phones would be imaged and that those documents would be produced. I think the SEC takes the view that responsive corporate documents, wherever they're located, should be produced. And I don't think that the SEC would have significant qualms about imaging personal phones. And I actually know from experience that they would not have real concern about imaging personal phones.
Great. The second question, do the broker-dealers provide business cell phones to employees? So I actually know that one of the larger broker-dealers that were subject to the sweep, as a result of the matter, they did issue separate business phones to everyone. And so they have a personal phone, they have a business phone, and the business phone has the archiving capability for all of the text messages.
I've heard that at more than one of the broker dealers. And I would also say, as an important piece of context, that's how the SEC operates. So the SEC issues staff a business phone, and then staff have a separate personal phone. It helps to inform how the SEC sees the world if you know that that's how they come to work every day with two phones in their pocket.
Another question, which I think we partly covered, what tips or techniques are being used to discover text messages or messaging apps outside of approved channels? How can compliance programs ensure compliance? And so I think this is really challenging. And I think the number one takeaway that we're hearing and would be the surveillance of the email communications that might indicate off-channel communications.
And I'll amplify to just say, I don't think this is ever going to be perfect. And I don't think, I would be surprised if the SEC ever expects it to be perfect. But I think a really strong demonstration of the good faith effort to capture these kinds of communications will go a long way in mitigating at least enforcement risk. It doesn't mean that there won't be an investigation, and it doesn't mean that there won't be exam inquiry. But I think taking many of the practical steps that we've been talking about does help to start mitigate the risk of an enforcement action on these issues.
So we received this question about the scope of the communications and what's a required record. And the question is, does this also apply to text communications between employees that may be regarding a directive on a client's account? And so I think the focus of that question was, it's not necessarily a written communication received or sent between the advisor and a client, it's between employees. This is my own personal view. I think if it relates to investment advice on a client account, I think the SEC would have an expectation that that would be a required record, even if it's not technically sent or received from the advisor to an outside party. If it's relating to investment advice, I think they would read the requirement to capture that type of communication.
I agree with Anne.
And then we received another question. Is it reasonable to adopt a control in your policy to permit personal communications between employees who are friends? For example, if you want to go out to dinner. I think that's probably reasonable. I have not seen that yet, but I think that's reasonable.
I think that's reasonable. I think I would also want to make sure you scope into your training the kinds of communications that you're talking about in that bucket, and be very clear about the kinds of communications you're not, because I do think one thing you want to be careful of is having employees making decisions on the fly about whether this is a communication that needs to be retained versus one that doesn't.
Another question relates to privacy, which is actually a question that Laura had sent in advance. I believe there may be privacy ramifications in some states, such as California, if you spot check a personal device. That's our understanding as well. We also think there are very restrictive privacy requirements overseas, particularly in the EU, on privacy issues. So before doing any type of spot checking on personal devices, definitely run that by the privacy attorneys. What exactly, this might be for you, Adam, what exactly is included in phone imaging?
Sure. So in phone imaging, as I understand it, and let me set the groundwork by saying I'm a lawyer, not a technologist, but my understanding is that a vendor is able to extract, essentially make a copy of the phone image, make a copy of the phone, and have all of that available for a forensic analysis, and certain portions of that data could be promoted to a review tool like the relativity tool that a lot of law firms use and a lot of the government uses to then go through and do a document review in preparation for a document production. I will say, in my experience, most of what the SEC is looking for when they are asking for a phone image, it's usually email that's locally there on the phone, as well as any notes, things like that, if you use the notes feature. But in particular, it's text messages that either reside in iMessage or text messages that reside in a third-party messaging app like WeChat. Those are the things that I think the SEC is really looking for, and those are usually segregated out from a phone image that then is available. I will also say that everything that's on the phone is imaged. So to the extent that is a meaningful thing to talk to employees about why you want to follow the policies such that you don't end up in a position where your phone is being imaged, that is worth conveying. There isn't, as I understand it, there isn't a good way for vendors to pick and choose what they pull off of the phone when they make an image. Now, they often will promote only certain pieces, or only certain parts of the data, for example, only text messages, but that's not always the case. I also think it's important to convey that deleting messages on a phone doesn't necessarily mean they're gone. They may still reside in an iCloud backup or in some other backup, and they obviously also could still reside on the recipient's phone, and that might be a phone that the SEC or another authority is going to access as well. So a long answer to say that everything gets imaged, certain parts might get reviewed, and even if it's deleted, it may well still exist somewhere else.
Great. Should we go to some of the prepared questions, Adam?
Sure. I think that's a good idea, and maybe the first one to talk about, if among the questions that came in, is we got some questions about policies and procedures, and maybe this is a good question for you, Anne. So first, when you're looking to update these policies and procedures, which you should do, what departments at the advisor need to be involved in that process?
Sure. So I think legal and compliance should clearly be involved. Compliance is really taking the pen on the actual update to the formal policies and procedures, but it's going to be really important to get buy-in, obviously, from your business partners and from the technology providers too. It's going to be important, as Adam mentioned in the undertakings, that the SEC expects an evaluation. You might not actually go that route, but an evaluation of whether or not it makes sense to find a tech solution, and if that's appropriate for certain pockets of your employee base. So I think that those are the types of key players that I would include in the development and enhancement of your policies and procedures.
And maybe a specific question about policies that I think maybe not industry standard, but were one of the widely used strains in the industry, at least going into this line of record keeping cases. how do you think about policies that just have a blanket prohibition on off-channel communications for business purposes?
So I think there are pros and cons to that, right? So the pro is that would satisfy, I think, the SEC in terms of their viewpoint about what would broadly be captured as a business communication in the 204-2 record. The con is that it's subject to very easily able to be tripped up, right? And so we've seen the approach of folks actually mapping out the policy to map out to the 204-2 requirements. That's challenging because you don't want the employees to kind of make the judgment call about what's on channel, what's off channel. What I think is more palatable, I think from a risk perspective, would be to include a very narrow carve out around administrative communications. We think that's probably the way to the preferable way to go here.
And I guess with respect to attestations, we've talked about moving them up to quarterly. Are there other things around attestations that should be done? And what do you do when you have this stack of attestations? Like what is the purpose here?
Yeah, so I think it's twofold. It's the SEC has an expectation of actually reminding employees of the requirement, and there's a kind of psychological aspect to being on alert. They really like regular email communications, regular reviews, and then these attestations. They don't expect that just an attestation will be sufficient, so they want it to be coupled together with testing and surveillance and the like. But attestations and training, sort of the whole picture, will go a long way in actually proving that you have a reasonably designed program for this result. Now, the actual attestations, it covers, we'd be happy to share that, Laura, after the webinar, but it goes into a lot of detail in terms of the requirement, a recitation of the actual policy at the firm, a requirement that if you do receive inadvertently an off-channel communication, that you forward that text message over to your email so that it can be archived in the business record. So there are a lot of different components to the attestation that we think the SEC would expect.
And what do you think about if you get so just following up with the point you just made, the idea that it should be moved back from off channel to on channel if it happens to come in off channel? Oh, is that me? Can you hear that, or is that just on my end?
Just on your end.
Okay, I'll just keep talking.
No, it's not just on your end.
Okay.
Yeah. Oh, okay.
I'm gonna mute for a second. There. Hopefully. Oh my gosh. Okay. And I may just let you go from here while I try to get somebody in.
Okay, no problem. So we received a number of other questions on the chat now, and I'm happy to go through them. So received a question: if the firm discovers an employee has used text messaging for business purposes, is it acceptable to ask that employee to screenshot all business communications and send that to compliance to be ingested? So that one is a tricky one, and I would advise discussing the particular facts in that scenario with counsel to determine the risk profile of whether or not you want to actually archive and go back historically and communicate and archive all those business communications. There are various, issues related to that. Once you have a historical look back of employees and having them screenshot, there's an issue about whether or not you've captured everything, right? Is it indicative of a more pervasive issue and sort of flags to the SEC a bigger problem here? So there are different approaches to this. And for that particular question, I would just caution and just evaluate the particular facts of your situation. And we're, of course, Adam and I would be happy to talk about your particular facts, but I don't think there's a bulletproof answer for that particular question.
Hi, Anne, it's Adam. I'm not getting the sound right now, so just let you know that I'm here and can speak if there's a question that's a good one for me.
Great. So another question: is it sufficient to add an attestation line on electronic communications to the quarterly personal security report, or should it be on its own? So formatting wise, I think it's perfectly fine to add it together with your regular, if you have a regular cadence of quarterly certifications, you can add on the additional reps to your regular quarterly certification. We don't think it needs to be a standalone document. Okay, so maybe Adam, we can talk about, I think there were questions earlier about what records are covered. We've gone through this a little bit, but maybe we can dig a little bit deeper. Text between employees, personal text with clients, what type of communications do we consider a required record that would need to be kept on channel?
Yeah, I think probably personal texts are not. And maybe it's easier to talk about what we would not expect. And so I think a personal text that is, that says I'm running late, or can you meet for dinner? Those kinds of things I don't think fit under the record keeping requirement. I think the risk, though, of having employees make decisions on a case-by-case basis is that there's the potential for it to be second-guessed by the SEC. The other risk is that a conversation about I'm going to be late to the meeting can sometimes morph into, oh, and did you, are you going to be there for the meeting with client X after, and do you have the deck? And before you know it, you have a communication that started out as one that wouldn't need to be brought on channel that is off channel. And so you end up, that wouldn't need to be brought on that now does, and you run a risk of having a lot of those communications and requiring a lot on a manual process for employees to migrate that back on. In terms of text between employees, I think the safer course is probably to include most of those in what you retain. There are sort of the very innocuous examples of like happy birthday, those kinds of things. You don't care about that, but again, maybe you don't want your employees making a decision about whether that needs to be brought back into the on-channel communications. And I would say, as a general matter, to the extent that they're texts between employees that relate to the business, even though those texts are maybe not precisely called for by the Advisors Act record keeping rule, the better practice is probably to have those inside the perimeter of retained communications if they're relating to business matters, because the SEC may take a pretty broad view and may expect you to have those. Text with clients, I think these are probably even more so than those internal employee texts. There's again the potential for a text with a client to be looking forward to meeting you tomorrow for a drink, and that doesn't really fit into any of the buckets. But there's again the potential for that kind of text to rapidly migrate into a chain that is going to need to be brought on channel, and you probably don't want your employees making that decision. In terms of other communications, personal emails, I generally, again, if it's like a personal text message, I don't think this is something that you need to worry about, or this is something that you need to bring on channel. But I do think this is where the training is really important, so that people understand that to the extent that they use that personal email for a business purpose, that is going to be something that the SEC is going to expect to be retained, and that's something that probably your policy is going to require that to be retained. And it should be an impetus for not communicating using that personal email about that matter. You should use a different format. I think the same thing is true for things like LinkedIn messages or other forms of communication. If the SEC is going to come in and say that that's the kind of communication that we would have expected you to retain, then the medium is not especially relevant. It's more the content and the nature of the communication, and whatever it is, it should be brought on channel.
So Laura sent a number of questions around devices in advance of the webinar as well. Does it make a difference if the device is firm issued versus BYOD? I think my response would be, the gold standard, I think now shifting is potentially to have two devices, right? One personal, one work. which goes to the psychology and I think behavioral risk around having a single device that can be easily intermingled. But technically, it doesn't matter, right? If you're having the substance of the communications is what is at issue here, and whether or not it's a required record under 204-2. So if it's an off-channel communication on either a BYOD personal device or a firm device, I don't think it changes the regulatory framework.
I agree, and I think it's not meaningfully different than personal email. If you start sending business communications from your personal email, it's not different than if you're using a BYOD device.
Right, and it doesn't matter if the firm pays for the device. It shouldn't. Again, going back to the content of the information, that shouldn't be a factor. Is it limited to phones, tablets, iPads? Not limited to phone devices, right? If you're having off-channel communications through your iPad, that could potentially be problematic as well. I think I have another question for you, Adam. Is SEC access to personal phones primarily granted through a subpoena? Are subpoenas always granted, and on what grounds?
So the SEC can issue a subpoena after it obtains a formal order of investigation. A formal order of investigation currently, and this has changed some over time, can be signed off on by a senior officer, of whom there are about 36, 37 senior officers in the Division of Enforcement. At that point, the subpoena can be issued, and the process for challenging that subpoena is, I should put a footnote in, the commission could always come over the top and deny a formal order. It's a delegated authority from the commission. The 5 commissioners are the body that has the authority, but that's been delegated to senior officers. But once a subpoena is issued, the subpoena respondents' options are compliance or essentially a motion in a district court to quash the subpoena. That is typically an unattractive option in most cases because SEC investigations are non-public, and filing a motion to quash a subpoena would essentially out the investigation, which many subpoena respondents would rather not do. There are opportunities to negotiate the subpoena, and in particular around personal phones, there is a lot of negotiation, and there could be a respondent could say, I'm not going to do this, which would put the SEC to its proof, and the SEC would have to consider whether it wanted to file a subpoena enforcement action, sort of the opposite of a motion to quash the subpoena, which would again make the matter public, which is not a positive from the subpoena respondent's perspective, but would also put the SEC to its proof in front of a neutral arbiter, a district court judge, who would then decide whether the subpoena that the SEC is seeking to enforce is really something that they should be doing. So there's a lot of nuance around it, and there are a lot of decisions that would need to be made. I think with respect to personal phones in particular, it's a place where you see defense counsel pushing back more than with most other subpoena topics.
I think we're just about out of time. I want to thank Adam Aderton and Anne Choe from Willkie so much. You've covered a lot of ground on this issue. I think you've given us a lot of food for thought on how to approach this, and we really thank you for your time and expertise today. We will post a recording of this call on our website under our webinars section, so please feel free to revisit it. Thank you everyone so much for attending today. Have a great day.